tribunal ought to consider the acts of United Kingdom company as not attributable to the attributable to the government of the United Kingdom. With that, members of the tribunal, I'll seek to welcome Co-Counsel Tali Israel Tali to proceed.
Thank you very much.
Thank you, Co-Counsel. Mr. Chairperson and members of the tribunal, as earlier introduced, my name is Tali Israel Tali, and within the next 27 minutes, I shall be guiding this tribunal with respect to the violations of the Free Trade Agreement, as well as with respect to the question of violation of the quantum of damages. To begin with the effect of violation of the FTA agreement, it will be the submission of the claimant that the respondent state violated Article 10.6 on expropriation, that secondly, the respondent state violated Article 10.5 on the minimum standard of treatment, and finally, the respondent state violated Article 10.3 with respect to the national standard of treatment. Finally, I will address the violation of damages, whereby I will substantiate before this tribunal that Mr. McLean is entitled to economic damages worth £560 million, and secondly, that Mr. John Foster McLean is entitled to moral damages. And with that, members of the tribunal, then I will proceed to my substantive submission. With respect to expropriation, and picking over from what my co-counsel has substantiated, members of the tribunal, that Mr. John Foster McLean has a covered investment. And secondly, my co-counsel has further substantiated that the acts done by the UK company are attributable to the state, and therefore they should be considered as acts of the United Kingdom. I will therefore substantiate that the measures taken herein amount to expropriation. In demonstrating that, I will advance three key submissions. That first, the acts taken by the UK Corps, the UK Ministry of Environment, and the UK Royal Police in frustrating and terminating Mr. John Foster McLean investment are expropriatory in nature. That secondly, the expropriatory acts taken were not in accordance with the standard for a lawful valid expropriation under Article 10.6 of the FTA agreement, and that finally, in any event that the respondent state alleges the regulatory measures police powers doctrine, such doctrine does not apply in the present case.
Counsel, your co-counsel has placed heavy reliance on the lease agreement as being the basis for the covered investment. That's right? Now, this lease was terminated. That appears from the facts. Therefore, the covered investment came to an end. Is that not factual?
It's factual.
The covered investment having come to an end, the rest of the acts of the UK government, the regulatory authorities, the Royal Police have no connection to the covered investment.
Thank you for your question, Mr. Chairperson. The question that arises is, was the termination of the lease agreements lawful? We do agree that the lease agreements were terminated. However, the factors that were alleged as in the pretext of the termination of the lease agreements, as the respondent's own domestic court of appeal held, Mr. John Foster McLean was not responsible for such acts. Secondly, my co-counsel has substantiated that Mr. John Foster McLean's investment does not only include the lease agreements, but they also include other tangible and intangible property. This includes, members of the tribunal, investments that Mr. John Foster McLean put in designing and structuring and constructing the Portland Quarry. This includes investment, the infrastructure he put in. This includes the property of Mr. John Foster McLean that was auctioned by the state. They all fall within the ambits of what is an investment under the FTA agreement.
Don't you think those investments are a result of the lease agreement?
They are indeed a result.
Now, if the lease agreement is terminated, that's going back to this question. Does that mean that even those other activities cannot be claimed under the FTA?
That then will, like I've already submitted, bring us to assess the effect of the termination. Was the termination lawful or unlawful? The Court of Appeal held clearly that Mr. John Foster McLean was not responsible for the violations held. Therefore, the unlawful terminations of the lease agreements herein then are held to be invalid.
But the Court of Appeal was deciding on a criminal matter of the arrest and the detention. Did not decide on the civil matter related to the contract itself, whether it was valid or not.
However, the Court of Appeal was clear that yes, it was deciding on a criminal matter, but what did the Court of Appeal state, member of the tribunal, that Mr. John Foster McLean was not responsible for the regulatory breaches that were alleged as a pretext for cancelling the lease agreement. The meaning of that statement, as per the claimants and as the claimants submit, is that Mr. John Foster McLean did not commit any of the violations that led to the termination of the lease agreements. That has the meaning that the lease agreements were terminated unlawfully. That means that the alleged means for terminating the lease agreements then were as an act of the respondent state, an act of bad faith, as I'm going to substantiate.
Is it possible that the Court of Appeal was making a differentiation between John Foster McLean, the legal person, and the entity that had entered into the lease agreement, which is obviously a separate legal entity, and therefore, if that legal entity was the one responsible for the regulatory breaches, can you still continue to ride on your argument?
Mr. Chairperson, that could be a possible scenario. However, in the present circumstances, the Court of Appeal could have been expressly clear and stated to that effect, like you have just stated. However, in the present case, the Court of Appeal was clear to the effect of its ruling, and it exonerated Mr. McLean of any regulatory breaches. Thank you. Then the question, as I was submitting, what are the measures that Mr. John Foster McLean is alleging that are expropriatory? And like we have already submitted, the termination of the lease agreement, the shutting down of the Portland quarry, the auctioning of Mr. John Foster McLean's property. These acts amount to a direct taking of the title of Mr. John Foster McLean. And therefore, as was substantiated, as the tribunal in the Bywater versus Tanzania case noted, such measures amount to a direct expropriation, and once a tribunal establishes that, then it should move to assess whether the measures were taken in accordance with the requirements for a valid lawful expropriation. Members of the tribunal, Article 10.6 of the Canada United Kingdom FTA provides for 4 requirements that are mutually inclusive and they are cumulative that must be proven for an expropriation to be lawful. Failure to prove any of the factors then renders the whole expropriation unlawful. These are that first, the expropriation has to be done for a valid, proper public purpose. That secondly, due process has to be followed. Thirdly, there has to be compensation, and finally, the measures have to be non-discriminatory. It is the submission of the claimants that first, the measures were not taken for a proper public purpose. Member of the tribunal, a proper public purpose has been held in ADC versus Hungary to include measures that have legitimate measures that have a benefit to the public as opposed to individual gains. Assessing the present measures in question, the respondent state did not provide any legitimate reason for expropriating Mr. McLean's property. However, looking at the actions and the allegations against Mr. John Foster McLean as being violation of UK's laws, that brings a question of enforcement of the rule of law. However, a similar question arose in ADC versus Hungary, whereby the Hungarian government had issued a decree, and it alleged that the effect of the decree was to make sure that the Hungarian laws are harmonized with the European laws, with the European Union directives that Hungary had just acceded to. The tribunal was quick to note that measures of bringing the claimant's activities under the enforcement of the rule of law in themselves cannot amount to a valid, proper public purpose. The tribunal has to go ahead and assess who benefits by the measures. In the present case, then, who benefits by the measures? Members of the tribunal, the respondent state auctions Mr. John Foster McLean's property. This is a direct act that has no link to a legitimate public welfare objective. It is the government of the United Kingdom through all the measures, destruction of the quarry, frustrating Mr. John Foster McLean property that goes ahead, in fact, to benefit from such acts, and it therefore can be seen clearly that there was no proper public purpose.
Isn't the public benefiting indirectly from the government's action? Where does the money from the auction go? The public purse, used for the public purpose, isn't it?
Thank you for question, and that will be an assumption which in the present case the respondent state has not substantiated. First, the reasons why the measures were taken, and secondly, whether the measures were benefiting the public.
They are saying that you operated illegally after cancellation of the lease. Isn't that the reason why they stopped your operations?
That is the reason, member of the tribunal. However, such a reason has been rejected. Such a reason as enforcement of the rule of law has been rejected by the ICSID tribunal in ADC versus Hungary. And therefore, we invite this tribunal to be persuaded by that decision and reject that measures of enforcement of the rule of law cannot amount to a proper public purpose. We then secondly submit that the actions taken by the respondent state were not in accordance with due process of law. Members of the tribunal, due process of law in itself has two requirements, as has been established by various arbitral tribunals, including the famous ADC versus Hungary. That first, the respondent state in taking the expropriatory measures has to work in accordance with the domestic, administrative and legislative laws available. And secondly, the investor should be accorded an opportunity to challenge the measures in the domestic system. In the present case, the lease agreements, which were providing the basis for Mr. McLean's investment, provide, to be precise, particularly at page 19 of 21, that before terminating an investor's investment, even where a covenant or condition under the list has been breached, there has to be a 60 days notice. In the present case, the lease agreements were capriciously terminated without any notice to the claimants. Secondly, the lease agreement provides at page 20 of 21, particularly paragraph 5, that even after the lease agreements have been terminated, the investor is supposed to be given between 3 to 6 months to remove their property from the respondent state, and that is after the 6 months have elapsed. That is the only period, that is the only time that the state can take measures against the investor's property. In the present case, after terminating the lease agreement, the respondent state goes ahead and auctions Mr. John Foster McLean's property without according him first 60 days notice, secondly without according him between 3 to 6 months period, so that he can remove his property from the area. This therefore clearly sees that the respondent state in taking the measures acted in violation of its own, of the domestic and of the legal and administrative procedure it was supposed to be followed.
The provisions of the lease agreement are between lessor and lessee, are they not?
Yes.
Very well. Carry on. I understand your argument.
Thank you. And then to that effect, then we submit. Secondly, with regards to due process, then the question that arises is, was Mr. John Foster McLean accorded an opportunity to defend his actions in the local courts? We do agree, and indeed we do understand that Mr. John Foster McLean had a case that went up to the Court of Appeal, the Apex Court. The Court of Appeal went ahead to make a ruling to the effect of exonerating Mr. John Foster McLean. However, it doesn't stop there. The respondent state has not taken any measures to give effect to the Court of Appeal's decision. The Court of Appeal exonerated Mr. McLean of the regulatory breaches. It was therefore only clear and reasonable that the respondent state could either have restituted the situation back to normal because the lease had just operated for 2 years, a position which the respondent state fails to meet.
But counsel, was that part of your prayers before the Court of Appeal, restitution?
The facts are silent, member of the tribunal.
It is your suggestion that they should have done that, but did you ask them to order that they do that?
An objective and dissection of the Court of Appeal's ruling imposes an obligation on the respondent state to act After the court has ruled, the respondent state will not just sit and wait, and the court has given a decision.
So I understand you to be saying that it was incumbent upon the state to restitute, having regard to the decision of the Court of Appeal.
A restitution could be one of the measures that the respondent state, if it were acting in good faith, could have taken. Then, having submitted that the measures were expropriatory, having submitted that the two of the conditions were not met, I will further substantiate that under the FTA, there is a requirement that there be payment of prompt, adequate, and effective compensation for an expropriation to be lawful. In the present circumstances, members of the tribunal, the United Kingdom, the respondent state, has not paid even an iota of compensation to the claimants. Therefore, this clearly renders the whole expropriation unlawful. Then this brings me with regards to my...
You're not putting the cart before the horse, because if you have a police in a functional state which receives a report that we have got an investor who is stealing rocks, who is acting illegally, surely you'd expect prompt and effective action from the police. So that ought to be the first action. And then, as to the remedial measures, came in the court decision which vindicated Mr. McLean.
Thank you, and I'm delighted that you indeed agree with me that the court vindicated Mr. McLean. However, as I'm going to substantiate, after receiving notification that he was allegedly stealing rocks, the respondent state acted in bad faith. And it is that act of bad faith that I will be substantiating under the minimum violation of the minimum standard of treatment. However, for the purposes of this expropriation, once we have proved that the measures are expropriatory, then the second requirement is, among the 4 requirements, there has to be compensation. Therefore, the state, under whatever the circumstances, as long as it was exercising expropriatory measures, it was obligated to compensate.
But should we take your silence to be a concession that everyone expects the normal police force to engage in prompt and effective action, which is, you receive a report that there is theft of rocks, you act on it. You receive a report that there is illegality, you act on it. Is that a concession you're making?
To that effect, I am making such a concession.
Understood.
And linked to then my submissions, allow me to submit thirdly, with respect to expropriation, that in any event that the respondent state raises the police powers defense as a justification for the measures, we submit that such doctrine should not apply here. That members of the tribunal, the doctrine is not cast on stone, but it also has in itself 3 requirements: that was it exercised for a public purpose, was it in accordance with due process of law, and was it non-discriminatory. Like we have already substantiated, the measures were not exercised in accordance with due process, the measures were not exercised for a proper public purpose, hence the doctrine cannot apply. However, in any unlikely miraculous event that the tribunal holds that that doctrine applies in the present case, we submit that recent tribunals such as Zurich versus Argentina have established an additional criteria of proportionality. That the police power doctrine is not cast on stone, that the state has to consider the effect of the measures it is taking as against the aim. That where the measure renders the claimant investment permanently deprived and neutralized, then the state is obligated still to compensate even if it were exercising valid regulatory measures. However, if the measures were only temporary measures that could be rectified and the claimant continue enjoying the investments, then for such instances the state need not compensate. In the present circumstances, the Portland quarry is totally destroyed. The employees are chased away, and the property is auctioned. This, therefore, members of the tribunal is clear. Members of the tribunal is clear that the proportionality doctrine was not complied with. This then brings me to address this tribunal with respect to the minimum standard of treatment. And with respect to the minimum standard of treatment, the FTA agreement provides that an investor shall be accorded fair and equitable treatment as well as full protection and security. Fair and equitable treatment has been held in Occidental versus Ecuador to include certainty and predictability in the actions of the host state. According to MTD versus Chile, various indicative factors have been put in place to determine whether there was violation of the fair and equitable treatment standard. These members of the tribunal include legitimate expectations. Where an investor had legitimate expectations, such expectations are supposed to be respected by the host state. In the present circumstances, Mr. John Foster McLean had legitimate expectations. The legitimate expectations members of the tribunal arose out of the lease agreements as well as the government policies in the UK, as well as governmental assurances of support and governmental invitation. According to the lease agreements, Mr. John Foster McLean entered into the lease with the knowledge that the lease would operate for a 10-year period, which was renewable for 5 years for a subsequent 3 terms, totaling the whole sum to 25 years. However, the lease agreements are capriciously terminated, and this violates the legitimate expectations Mr. John Foster McLean had while investing in the United Kingdom. With respect to the full protection and security requirement, the arbitral tribunal in AAPL versus Sri Lanka held that the state is obligated to refrain from destroying the investor's property. In the case at hand, in a counterinsurgency operation, security forces had destroyed the investors of the claimants in the case. The facts are analogous to the present case whereby Mr. John Foster McLean's investment is destroyed by the Ministry of Environment, his property is auctioned, and therefore this one clearly shows that the full protection and security requirement was not met. Members of the tribunal then allow me to address this tribunal with respect to the national standard of treatment. It is the submission of the claimant that for there to be a violation of the national treatment of standard, 3 cumulative factors have to be met. That first, a local comparator has to be established. 2, that they have to be in like circumstances. And finally, they have to be accorded less favorable treatment. I'm inviting this tribunal, and indeed the claimants are submitting, that there is a local subject for comparison. The question is, who is the local subject of comparison? Members of the tribunal, Mr. McLean, the actions are taken against Mr. McLean as an investor. It should be understood by the tribunal that Mr. McLean is a 49% shareholding in the company that he invested through Crust. The other 51% shares, according to the fact pattern, are held by United Kingdom nationals. It is therefore clear that there is a local subject for comparison. That the local subject is the 51% shareholders, members of the tribunal, who are in like circumstances with Mr. John Foster McLean. The question then is, was there less favorable treatment? We submit that in the present case, Mr. John Foster McLean is arrested and the measures are taken against him alone. Similar treatment is not given to other investors who were in the same business and like circumstances with Mr. John Foster McLean, and as such, members of the tribunal, the national treatment standard is violated.
Excuse me. Now we have this agreement that was terminated, where Mr. McLean had the 49%. Now that implies that there are other 51 that have the associate shareholders in the company. So are they claimants here?
They are not claimants here. The 51% shareholders, according to the fact.
So why do you say that it's only Mr. McLean, yet there are other shareholders that are not complainants here?
The other shareholders are not complainants here, and in fact, your question supports our point. Why? Because the measures were not taken also against them. The measures were only taken to Mr. John Foster McLean, yet the other 51% shareholders were in like circumstances with Mr. John Foster McLean. Had the measures
were taken against the company that he owns with others.
The arrests, member of the
Not arrests
tribunal.
only. Well, of course, there are a number of measures.
Yes.
It's about arrest, the other is about to not give you the approval, the number of things. Now, all those measures, I think, they are against the company that he owns with the others. Now, why is he only the one claiming and not others
To that effect, I consider and agree with you that the measures are against the company. However, with respect to the national treatment of the violation of the national treatment of standard, the measures the claimants are alleging in question are the measures of the arresting, harassing, and unlawfully detaining Mr. John Foster McLean. Then this will allow bring.
So, whilst I applaud your ingenious argument, isn't Mr. John Foster McLean the directing mind and will of the entity?
I agree with you. Is in fact in control of the whole business. However, the measures are not taken against him as a director. The measures are taken against him as an investor. So the question is, were there other investors? Yes, they were. And therefore, taking the measures against him amounts to less favorable treatment than the one given to other investors.
Your argument that the measures are taken against him as an investor comes from your prism or the platform upon which your action proceeds, right? Now, when the police are taking regulatory action, such as they did, do they look at him as an investor or do they look at him as a director?
In the present circumstances, they looked at him as an investor.
And what is the basis for that assertion?
It is clear from the fact pattern that Mr. McLean, the reasons for his arrests were solely tied to his investments. He was allegedly, there was allegation he was stealing rocks. That was tied to him as an investor. It is him as an investor that was carrying out the mining, not him as a director. Thank you then. Allow me to quickly address this tribunal with regards to the quantum of damages. And we submit that Mr. McLean is entitled to £560 million of economic damages. In arriving at the £560 million, the tribunal is persuaded to consider the Chozu factory formula case, which provides that where a state takes unlawful measures, then full reparation has to be made. This has to be distinguished from the Hull formula for a lawful expropriation. In the present case, we have substantiated that the measures taken were unlawful measures, and therefore the formula to be applied is the Chozu factory formula case. With respect to calculating and arriving at the figure, we therefore persuade this tribunal to consider the value of the investment presently had the actions not been taken. This is through the method of discounting future cash flows to calculate net present value of the investment according to the market value.
The investment is by Mr. John Foster McLean and other investors. Is that correct?
Yes.
So have you given consideration to the other investors, and therefore does this 560 million constitute his proportion of the investment?
Though the facts are silent, but we can objectively dissect the fact that the 560 million pounds was arrived at by economic experts.
He accepts that.
And the 560 million is the value of the whole investment, the entire investment.
So Mr. John Foster McLean walks away with the entire investment.
Should this tribunal accord Mr. John Foster McLean 560 million, then we will go back and then to the company and look at how much then Mr. John Foster McLean entitled to. 80% of the profits. He's a 49% shareholder. We will assess all those factors, and then we will give the rest of the money to other shareholders.
That before you claim. Because if he's going to walk out with the 560 million, how are other claimants, when other shareholders going to claim their share?
Mr. McLean acts in good faith and cannot run away with the money of the other investors.
Counsel, the other shareholders do not have the standing before this tribunal that Mr. McLean has. Therefore, they cannot take the benefit of an award of damages from this tribunal, can they?
Mr. Chairperson, if I get you rightly, and you will agree with me that the damages are awarded to the investment,
Yes.
and not to Mr. John Foster McLean.
Mr.
The
John
economic
Foster McLean comes before this tribunal because of his standing as an investor.
Yes,
Correct?
yes.
The other shareholders do not have that standing. So you're asking us to award damages equivalent to the total value of the investment. And then your suggestion, as I understand it, is that as counsel, the tribunal should trust you post-award to go away and apportion to the other shareholders. Now, two problems arise there. Number one, that the tribunal should leave it to you to undertake that apportionment. But number two, that a section of investors who do not have standing will then benefit from an award from this tribunal. Is that something sustainable? Is it tenable?
Mr. Chairperson, on the other side of the coin, if we will have come here to claim only damages to the extent of the percentages owned by Mr. John Foster McLean, and also let the other investors to come and claim for their damages, we believe they could not claim, they couldn't have a legitimate claim, and this tribunal could in fact dismiss their claims at the preliminary stages.
Yes, of course.
And so it's based on that we are persuading this tribunal to award us 560 million pounds as the value of the investment. Then the other local issues with regards to the companies will be sorted out.
Now, what persuaded the tribunal to believe that Mr. McLean has a mandate for other shareholders to represent them in this matter? And one second, assuming the tribunal accords the 560 million, are you giving assurance to the tribunal that these are the shareholders are going to get their part?
Thank you. And if you'll allow me 1 minute to answer your question because my time is up.
We must stop now. Thank you very much for your...
Okay, thank you.
We will now turn to the respondent.
The chairperson of this tribunal, and all the members of the tribunal, good afternoon. My name is Mumbe Abraham, and together with me is Ms. Kanani Daniela, who are agents for the respondents, and we are team RM206. We are going to respond to the claimant's claim using 45 minutes. I will use 23 minutes, after which my colleague will use 22 minutes. In responding to the claims, firstly, we shall object to the jurisdiction of this tribunal in handling this